Hi, I'm Marla McCowan, Director of Training, Outreach, and Support with the Michigan Indigent Defense Commission. In February 2021, the MIDC approved and published resources to assist trial court funding units with plans for compliance and identification of funding needs for fiscal year 2022. The MIDC staff has been working to assist systems with compliance planning. We hope this short tutorial helps identify what's new for fiscal year 22. The quick highlights of some of the topics I'll talk about include the following. First, there's a new standard, MIDC Standard 5, which was approved by LARA on October 29, 2020. This standard requires that public defense function independently from the judiciary. This is a new requirement, even though many systems have already started implementing independence in previous plans. This year, every system will need to have a plan for compliance, and the MIDC will expect compliance with the standard according to the statutory timelines after funding for fiscal year 2022 is distributed. Next, the local share has changed. Every year, the total system cost includes a local contribution, which by statute increases from the base that was originally calculated in fiscal year 2019. This year, the increase is 1.2% from that 2019 base. Third, we have a new grant management system called eGrams. Many of you are familiar with this platform through other grant-funded programs. Throughout April, we will have a series of live training events for new and experienced users designed to guide everyone through the new process for submitting plans and costs. Fourth, there's a fixed date for submitting the plans and costs, which by statute is April 27th, 2021, or 180 days from the date that Standard 5 was approved by the LARA director. No extensions have been authorized by the MIDC. Finally, all plans and costs will be reviewed by the MIDC within 90 days from the date that they are submitted. Please pay attention to our website, which has a calendar of dates where plans and costs will be reviewed by the MIDC. The Commission has regular meetings 6 times a year, including in June, but the Commission has added a July date to ensure that all plans are addressed in a timely manner. We have a number of resources designed to help systems complete and submit the compliance plan and cost analysis as required by the MIDC Act. The main resource that we use to post materials and information about all activities of the Commission, including compliance planning and grant funding distribution, is our website, www.michiganidc.gov. Please bookmark this site and check on it regularly, including the Grants tab, which can be located on the home page of our website. The grants page has several resources for planning, including a Word document of the compliance plan that you can type on and send in draft format to your regional manager for review prior to submission. There is also an Excel version of the cost analysis that you can use for the same purpose. Our grants manual covers all aspects of planning for compliance, allowable costs, and reporting, and was recently updated in February of 2021. Our website has the most recent version of the grant manual, as well as a table of all the changes in PDF format that you can review to see what's new. All systems are required to have a plan for compliance with the standards that have been approved by the MIDC and LARA. Those standards include training and education for attorneys accepting adult indigent criminal cases within the system, attorneys meeting with their clients in a timely manner and in a confidential setting, a process for having access to expert and investigative resources, counsel at first appearance and all critical stages of the proceedings, and now independence from the judiciary. There are other standards that have been approved by the MIDC covering topics about caseloads for assigned counsel, qualification and review of attorneys, and compensation for attorneys accepting assignments. The MIDC has also recently approved a standard to screen adults charged with crimes for eligibility to have counsel appointed if they're determined to be indigent. The full text of the approved standards and those pending approval are on our website at www.michiganidc.gov. The standard that we have gotten the most questions about is the new standard, requiring that public defense function independently from the judiciary. Many systems are wondering if they are currently compliant or what they will need to do to become compliant with this standard. The MIDC has answered the most common questions in a document on our website called Answers to FAQs. You can find those answers on the grants page or on the standards tab on our website, specifically Standard 5. You are also welcome and strongly encouraged to contact your regional manager at any time you have questions about compliance planning, implementing the compliance plan, or budgetary requirements for meeting the standards. All regional managers have already reached out to their local systems for compliance planning and to remind systems about the deadline for submitting the plan and cost analysis. Please plan to schedule meetings in the next few weeks to finalize your plans or send drafts to your regional managers pursuant to the instructions and timeline that they have provided to you. The MIDC will offer a series of trainings specific to the eGrams submission process designed to help systems submit their plans and costs. We'll go over setting up a user profile, entering plans for both new and experienced eGrams users, how to address any concerns identified by the regional manager if revisions are requested by staff prior to that April 27th deadline, and some small group tech support as we get closer to that deadline. You can sign up for training using this simple Sign Up Genius site, and I'll repeat this slide at the end of the tutorial. But please remember, these trainings are not designed to answer system-specific requirements about planning. Again, you should contact your regional manager for that purpose and follow your regional manager's instructions and timeline for review and feedback about the plans and costs you're drafting for fiscal year 22. So because there's a new standard requiring independence from the judiciary, some questions have been added and changed from the MIDC's prior compliance plan application. I'll walk through those changes. Please note, we use the term compliance plan as set forth in the MIDC Act, but sometimes we also refer to this as an application. So those terms are used interchangeably and refer to the detailed narrative portion of the Indigent Defense Delivery Systems plan for meeting the objectives of the approved standards. The narrative questions should be familiar with the exception of the changes that I'll note in a minute. You can follow along in the Word version of the plan from our website, and I encourage you to use the Word version to work through planning if you haven't already started. You will enter the information for the compliance plans in eGrams, but the questions in eGrams are identical, and in fact, you can copy and paste from your responses in the Word document into the eGrams platform. So please plan to do so. One tip we're offering is that it is really helpful to print the plan and cost analysis after you work through those documents and the content is in final form. Because the questions in the Word document follow the questions in eGrams identically, printing the application and cost analysis and tracking along those documents while submitting on eGrams will reduce the chance of missing any questions. It also provides a backup or a guide so you know what's coming as you work your way through eGrams. Starting at the beginning of the compliance plan application, the very first question asks about the type of indigent defense delivery model that's used in your system. This question is similar to questions in previous plans, but we've added an option reflecting a recently popular regional coordination of services. If you aren't sure what type of system you have, you can always check in with your regional manager. And if you're planning to change your delivery system, for example, from a contract defender system to opening a public defender office, the MIDC would like to see a feasibility study with detail to allow the commission and staff to review system impacts. Please see the grant manual for information about feasibility studies and check with your regional manager for samples and reimbursement of cost information associated with this type of planning. Now let's walk through the changes to the language about meeting the objectives of the standards. Beginning with Standard 1, Training and Education of Assigned Counsel, the Commission is looking for information about the plan for training attorneys. So all attorneys have to complete 12 hours of relevant training each calendar year. New attorneys or attorneys new to accepting assignments are required to complete a multi-day skills training course of at least 16 hours. See the MIDC's website on the CLE tab. CLE means continuing legal education, for information about the specific requirements for training. The Commission is interested in information about training new attorneys, how the training will be tracked for all attorneys, and how non-compliance with the training requirement will be addressed by the system. All of the standards questions will ask about changes to funding needs from the prior year, which might involve, for this standard, for example, accessing new training programs for attorneys or recalculating the registration required because attorneys have been added or removed from your list. Information about those costs should be addressed in the cost analysis. You don't have to put that here. But these questions alert you to the fact that changes should be addressed because changes in funding is a relevant consideration and point of review for both the staff and the commission. Standards 2, 3, and 4 are all prefaced with a reminder about Standard 5 and the requirement of independence from the judiciary in the selection of assigned counsel and access to resources for the defense. Most of the questions for these standards haven't changed, but please think about your current system and whether you need to make any changes to your answers to implement independence. You will want to review the answers to FAQs for Standard 5 prior to completing these portions of the application. And one clarification within Standard 2 questions regarding the timing of meetings asks whether there's a difference in payment to attorneys for meeting clients who are in custody or out of custody for the initial interview. Please note that new question. The other component of Standard 2 involves the setting of the meeting and seeks information about confidential meeting space in the courthouse, as well as a specific breakdown of the rooms available for attorneys to meet with their clients who are in custody or out of custody. Please provide sufficient detail about those spaces so that staff is able to ensure meeting the objectives of the standard. Standard 3 addresses the use of experts and investigators. In the past, questions spoke to policy, but that was confusing or sometimes led to incomplete answers in systems without formal written policies distributed to counsel. So instead, the question now has been reframed around process, and the balance of questions look for information about the process for requesting and obtaining those services. We're also asking a question about how those requests are tracked, which matches up when it's time for reporting during the quarterly program reports. Standard 4 requires counsel to be present at arraignment and all critical stages of the proceedings. You will see questions asking about both the circuit and district courts. If you're only submitting a plan for a district court, please just indicate that the circuit court questions are not applicable. In terms of payments to counsel for these appearances, please be prepared to address how attorneys are paid for their work in these different proceedings if different schedules for payments are used in this system. The MIDC has previously sought information about representing people incarcerated within the Michigan Department of Corrections. If you have a prison in your system, please address how counsel is provided. If you have a prison in your system, it is incorrect to say not applicable, and your plan will be rejected if you don't specify how prisoners are represented if they're charged with a crime committed within your system. Please also note that if you receive reimbursement for providing services from the MDOC, that must be reported at the end of the year in your financial documentation called the Unexpended Balance Report. The MIDC continues to collect information about providing counsel when systems offer the opportunity for defendants to plead guilty by mail or plead at the counter in a courthouse. Please describe that process if it's available in your system. In addition to a change in funding needs for Standard 4, please describe any changes to how counsel is compensated in the cost analysis. The biggest change in the compliance plan application involves Standard 5, requiring independence from the judiciary. All of the questions in this section are new. And again, we strongly encourage you to review the answers to FAQs about compliance with this new standard, which is available on our website and on the grants page and on Standard 5 of the standards page at michiganidc.gov. Systems are required to provide detailed information about how attorneys are selected, including who is involved in the selection process. There are also a series of questions about the assignment making process, reviewability, including requests for expert and investigative assistance. And the final series of questions asks about a process for the attorney to seek review of billing concerns or the denial of an expert or investigator, essentially an appeal process. There is no one-size-fits-all response, and the commission is not offering canned language to copy and paste into these answers. But the answers to FAQs do provide some options in terms of process and should be reviewed prior to developing the plan for compliance with this standard, or to check for compliance with the standard if independence has already been implemented in your system in part or in full. The compliance plan also asks about personnel. This includes direct service providers, typically meaning attorneys providing representation and their support staff team. But it might also refer to ancillary personnel, including in many plans, a clerk that assists with data entry or reporting in the system, or corrections staff moving defendants who are in custody in order to facilitate compliance with standards 2 or 4. If you have ancillary staff, please be prepared to address exactly what standards they comply with, and an explanation about how you are or will track their time, and a time study also if requested by a regional manager in order to provide an analysis about the spending to the commission. Please refer to the revised grants manual about the hiring of ancillary staff. And for any other costs, such as supplies or equipment, please just address those in the cost analysis. There aren't any questions in the application itself this year. Systems are entitled to seek reimbursement for the cost of planning under the MIDC Act. If you are seeking reimbursement, please provide documentation about the cost of planning and also include the exact total you're seeking to be reimbursed. You'll enter this in the cost analysis. Previously, there was a space in the cost analysis to provide information about the attorneys who provide services in your system, but we're asking for that information before the cost analysis is entered. This is largely the same information that you entered in the tab that looks like this Excel spreadsheet. So you'll need to complete that information now in eGrams. In some systems, if we have confirmed that our information is current, we can upload the attorney list that you provided through the program reporting due in FY21 at the end of the first quarter and by January of 2021. If we don't have that information, or if it's not loaded for you when you get to this page in eGrams, you will have to populate the names and P numbers for all attorneys providing services in your system. Don't leave this blank. A list of attorneys is required and a plan will be rejected for failing to identify the attorneys providing adult indigent criminal defense services within your funding unit. The cost analysis itself has not substantively changed from fiscal year 21. The primary difference again is that the costs will be submitted through the eGrams system. Just a few things to note. I mentioned at the beginning of this tutorial that the local share has changed. Every year, the total system cost includes a local contribution, which by statute increases from the base that was originally calculated in fiscal year 2019. This year, the increase is 1.2% from that 2019 base. When you're completing your cost analysis through eGrams, the total system cost will appear in the source of funds tab, and the local share for fiscal year 2022 has been calculated automatically for you. You can contact your regional manager if you think the local share is incorrect. But otherwise, the math has been done for you and there really isn't anything else for you to do in terms of adjustments from the base approved in 2019. Depending on your system, you may need to complete a separate tab in the cost analysis if you use a vendor or nonprofit public defender office. This only applies to a few systems, but for those who do use that model, the detail for spending by the vendor is required by the commission. Both versions are available on our website for your drafts and planning. The only difference is the additional tab for the vendor model, which you can see displayed at the bottom of the Excel spreadsheet. When you're in eGrams, that tab will be displayed along the top ribbon, and completing it will be required if you identified this model for your system before starting the cost analysis. At the beginning of this tutorial, I talked about timing. There is a fixed date for submitting the plans and costs, which by statute is April 27th, 2021, or 180 days from the date that Standard 5 was approved by the LARA director. No extensions have been authorized by the MIDC. When you start your FY22 application in eGrams, you will get a reminder about that date with a warning that the deadline for submission is April 27th, 2021 at 11:59 p.m. Please note the MIDC staff is only available until 5 p.m. on that date. So waiting until the last few hours to submit the FY22 compliance plan and cost analysis through eGrams is not recommended. There are plenty of opportunities for training, support, and assistance before then. Please follow the recommendations around timing and review of the plans and costs outlined by your regional manager. We will make sure people have training to set up their user profile in eGrams beginning on March 29th. And after the user profiles are created, systems can immediately begin the process of entering the plans and costs in eGrams. We will have training for new users and people experienced in eGrams in the early part of April. And we will also have training on making revisions through eGrams if any are requested by the MIDC staff prior to that April 27th deadline. We have an easy system for signing up for training through this Sign Up Genius website. You can choose as many trainings as you would like, and if necessary, we can add more options to accommodate everyone. If these dates or times don't work for you, please contact your regional manager for additional options. Staff will communicate the recommendations regarding the plans and costs that will be provided to the commission. With enough time for review, we're happy to do that during the drafting and planning stage and significantly prior to April 27th. Staff cannot and will not provide substantive feedback on the due date, and staff cannot extend the statutory deadline for submitting the compliance plan. So please don't wait until the last minute. We're here and we're happy to help and happy to make planning and submitting as easy as possible.